Thank you.
Good evening. This is John Milburn for Laws 11059, Statutory Interpretation. This is week 2 of term 3, 2018. What a great roll-up. We have a very keen group. I've got a good feeling about this group. I think we're all going to do very well. What I encourage you to do is now start to speak with each other, share ideas. If you come across a website, please share it with us. Now, up for the last 5 or 6 years, I've used a thing called UCrew for discussions. We're not using that this term. So we're using the Q&A section. If you come up with something that is useful, that others might wish to know about, please add that into Q&A or general discussion. And by all means, please ask questions. Tonight, if you wish to ask a question, please unmute your microphone and ask or use the chat facility. I'm going to ask you to tell me if you understand. You can just say yes or no to this. We'll just do a quick straw poll just to get you started. So, yes or no, do you understand the difference between legislative intention, legislative purpose, and legislative motive? Let's have a look at the results as they come in. We're getting a few no's. We're getting more no's. I like the kind of and sort of and so-sos. We haven't actually had a yes, which is very wise, because if somebody had said yes, you know what might happen. So a lot of no's and a few maybes. Let's have a look at it. And you might ask yourself, why am I asking you these questions? And the reason is that at an early stage, I'm very keen for you to develop some form of system or data bank or manner of accessing information that works for you. Now, if you're completing Introduction to Law with me at the moment, then you'll be aware that we're going to have you build a toolkit. And the idea of the toolkit, which is Assessment 2 in Introduction to Law, is for you to build something that you can use throughout your studies and indeed your career. If you like, your methodology for finding information and resources. If you're not doing Introduction to Law now, you may have done it previously, and if not, the concept remains the same. So when you're studying statutory interpretation, I do want you to have a way of locating information and being able to identify key words, phrases, and cases in legislation fairly quickly so that you can rely upon it. And then as you build this, you'll become more attuned to looking for individual words that may make a difference. And the good thing about statutory interpretation, of course, is that we have an opportunity to study individual words and phrases and challenge what was meant, what was the purpose, what was the object, what was the motive behind creating those words in the first instance. So, intention. Do you think it means, so when I talk about legislative intention, firstly, would you accept if I said to you that it is different from legislative purpose or object or legislative motive? So we're happy to accept that. All right, let's see if we can support it a bit further. Intention relates to the meaning of the enactment. Purpose or object relates to the mischief to which the enactment is directed. And motive relates to the political reasons for legislating in a particular way, at a particular time, and for a particular purpose. So there is this difference between intention, purpose or object, and motive. And I'll just say as an observation, and I've never actually said this previously in all the time I've been lecturing, it just occurred to me. When I attend CPD sessions, if the camera's on me, people might be unnerved because they'll see me talking in behind, and they'll be seeing me talk, and they'll think I'm not paying attention. In fact, quite the opposite. So sometimes I turn the camera off because it might be off-putting. What I'm doing is I'm using my voice whilst mute to record notes on the session. And for those of you that may be doing Introduction to Law, you'll be wondering why I challenged all the students to a typing test, and it's simply because I use my voice and I'm very fast in doing so. So just to digress, think about using typing as we go, or if you are a sort of person who uses your voice to do so, feel free to record notes using your voice in a form that works for you. Otherwise, good old pen and paper as we go is always good for notes. I hope that makes sense in terms of that slight digression. Are there any questions about note-taking? Good. All right. Now, I think there was one. Can I please repeat what I said? I'll do that now. Intention relates to the meaning of the enactment. Purpose or object relates to the mischief to which the enactment is directed. And motive relates to the political reasons for legislating in a particular way at a particular time for a particular purpose. Now, Sky, do you have a question? No questions from Sky? Any questions? All right, let's move on. I'm going to say what I'm about to say guardedly because it is really a historic perspective and I don't want you to get hung up on historical issues. One thing that really does bug me, we get this from time to time, is I'll go to a seminar and at the start you're probably able to take more information in it than you are at the end. I guess it's just natural. And sometimes people will say, they'll go into some detail explaining something, and then 10 minutes down the track after you've really concentrated to take it in, they then say something like, now that's what the law was, all of that's been changed, and now the law is this. And it drives me a bit batty. So what I'm doing is I'm giving you due notice. I'm about to give you a reflection on the common law in relation to statutory interpretation, which is still important. We still refer to it, but it's not the primary source. We look to legislation primarily, but to understand the legislation, to understand how to interpret statutes, it is important, I think, that we consider the common law position because we still do talk about it. In terms of the common law, we talk about different, almost competing rules or approaches. If you've done your reading, you might know what I'm talking about, although I do like the way Sanson does this. Michelle Sanson raises these issues primarily in about week 8 or so. So well done, so that you're not getting confused. But can anyone tell me any of the common law approaches to statutory interpretation? Unmute your microphone or use the chat facility.
Golden rule.
The golden rule, yes.
Literal approach.
What was that? The
literal approach.
Literal approach. I think Nigel came in with that as well at the same time. So the literal approach, the golden rule, I think there's 2.
The mischief rule.
The mischief rule is 3, very good. And very late in common law, which is kind of what we adopt now, is the 4th. When I went to law school, it was 3, but now there's 4. What's the 4th one? If you like, the modern approach. Very good, Gareth, the purposive approach. So we will talk about those during this unit. We talk about them in practice, and we'll talk about them briefly now. The literal approach, as the name implies, means taking the words on the paper and applying the strict literal meaning to those words. Let's take an example of where that may not always work, or it may not be able to ascertain with certainty what I mean. Now, this isn't a book, this is just something I made up. Let's assume that we're not talking about a statute, but we're talking about some, I don't know, right of entry. You go to the cricket, the football, the softball, the netball, whatever it is, you go to some form of sporting event or rock concert or whatever, and you are apprehended by a security guard who hauls you away. You've done nothing wrong, and chastises you and threatens to evict you for breaching the local rule because the sign at the entrance said, "No glasses allowed in this stadium." And when asked, you say, "Well, you're wearing glasses. No glasses allowed in this stadium." And I'm adopting a literal approach. Do you get what I mean? Can anyone guess perhaps what they may have meant when they said no glasses allowed in this stadium?
No cup glasses.
Yes, no cup glasses, no glass bottles, no cups, no beer glasses, no drinking glasses. So do you see what may go wrong with the literal approach? Now, of course, you might argue, well, what I'm wearing is spectacles, not glasses, but there are different things, different ways we describe things. So our language is good, but it's not perfect, and it's prone to ambiguity, and adopting a strictly literal approach can sometimes lead us into error. So the words in the legislation need to be interpreted beyond simply that one word into context. Yes, and people with Asperger's may take that kind of approach. So the literal approach can create some absurdities, yes. So words in legislation, we need to consider it within context. Now, what do I mean by context? Context of what? Any thoughts? It's all very well to say, well, you've got to consider it in context, but what's the context?
The context surrounding, sorry, John, the context surrounding legislation. So the purpose of the legislation itself, so taking the whole act into account when considering that one section.
Yep, so some really good responses there. So Gary says, you've got to consider the whole act if it's within a statute. Amy says the environment. Megan, the situation being applied. Gareth, the section the legislation relates to. Sky, the relevant details. So all of those things are correct. So what it tells me is that when we talk about context, there's not necessarily just one context. There might be different forms of context, and we need to consider a lot of different things. Now, I really do like this approach, and I think, again, because I'm taking Introduction to Law, I may be repeating things if you're doing both. But when I see a text like this, or a statute, pretty much anything really, maybe not a novel, because it probably doesn't work very well for a novel, but I like to flick through the contents first. Go to the contents, get a feel for the whole book, get a feel for the whole statute, take particular note of the headings, and this is relevant when it comes to a statute. Sometimes get an idea of how much of the statute is devoted to a particular topic compared to others. So get a feel for it overall before you start to read in detail. And then I'll often work kind of back, you know, the old take the book and flick the pages back, like you're creating one of those little moving cartoons with stick figures, and just flick through, get a feel for it, look for what appears to be important aspects, so that before you start to read, you've got an idea of where the author or the person who drafted the legislation is going with all of this. Does that make sense? So that's kind of a good way to start with context. Doesn't really work with novels because you don't really want to know who the murderer was when you start the book, I guess. But you get what I mean. And also think about the wider context, which was, as Amy would put it, the environment, for example. And that's all very important. So the literal approach is fine, and sometimes it applies. It means that we adopt the plain and ordinary meaning, but it does result in circumstances that might be inconvenient or improbable. Can anyone tell me if you like, the leading case on the use of the literal approach? High Court decision from 1920. I'll give you that hint. So when we talk about the literal approach...
Amalgamated Society of Engineers.
Engineers case, yes, absolutely, absolutely. Thank you, Gary. So when you talk about the literal approach, think engineers case. And that was the dominant approach for many years. But then we adopt a different approach, and very important case, one that you'll become very familiar with if you're not already, is Project Blue Sky, Inc. v. Australian Broadcasting Authority, 1998, 194 CLR 355. Now, I'm sure that all of you are aware that Project Blue Sky is the subject of the second part of your assessment in assignment number 1. We are all aware of that, aren't we? And I'm not mistaken, am I? So it's there? All right. So you'll need to know that case. What that means is whenever you come across that case, you've got to pay attention. As my old rugby coach used to say, if you're in your it was 22 back then, if you're on your 22 or the opponent's 22, you've got to pay a particular attention. You've got to really stir and concentrate hard. So I want you to do that at various times, particularly if you see Project Blue Sky. There's another use for Project Blue Sky. In practice, it's kind of a go-to case. So if you ever have a situation where you need to answer a question in relation to statutory interpretation, or you wish to mount an argument based on statutory interpretation, you probably almost certainly will put that case in as some form of authority or basis for your argument in most circumstances. Does that make sense? All right, so it's kind of a go-to. When I'm marking an assessment, I'll always be looking for that case. So toss that in as a regular thing. Okay, so that's the literal approach. Number 2, the golden rule. What does that mean, the golden rule? I'll give you a hint. It's a variation on the literal approach. The golden rule.
I'm just quoting from Michelle's book here. It says the golden rule developed as an exception to the literal rule, allowing courts to modify the ordinary meaning of words where literal approach caused an absurd result. That's
it. Perfect. And I like the way that you cited your authority. Always very important if you're referring to an external source to cite your authority. Thank you very much. And Gareth says, change a word to get around the absurdity. Yep, exactly. So what you're doing is you're adopting the literal approach, but with a little twist of lime. You're saying, okay, that's fine, but we'll do so in a way that avoids an absurd or inconsistent result. So are you wearing spectacles at the swimming venue? Fine, you can come in. You've got a glass bottle, you can't come in. So that's more the golden rule. What's the mischief rule? Any thoughts? The mischief rule. Whose mischief? What mischief?
Is that what
Any thoughts? Yes, Ian. No, I think, oh, sorry, Gareth. I think Ian was speaking, but I'll just unmute the microphone for you.
Okay.
Yeah, sorry. Did you want to add something there, Ian?
The mischief rule is where the legislation is drafted to address a certain mischief.
Exactly. Something that needed to be resolved has been dealt with. Gareth, did we steal your thunder there? Was that what you were about to? Yes, we did. Thank you very much. And thank you for that contribution, Ian. So that's the mischief rule. What's the case that established, if you like, the mischief rule? It's very old. This is about as old a case as we'll ever cite in this unit.
Hayden's case.
Hayden's case, exactly. 1584. So even then, there was talk about considering what Parliament sought to consider in making an enactment. What was the mischief that Parliament purported to attack or deal with? All right, so that's kind of the old common law approaches. That's what I learned in the late 70s when I did law school. What do we do now? The purposive approach. So it's where we're considering the purpose of Parliament in enacting the legislation or a provision to adopt interpretation that is consistent with the purpose. So
just ask a question quickly.
Yes, Lachlan.
Sorry.
Yeah.
Do you have a particular case that I could reference in terms of the golden rule?
Yes.
As well.
That's a really good question. I'm thinking off the top of my head. I think Adler case was probably a good one, but I haven't got one that I immediately comes to mind.
Okay,
but that's
cool.
a good thing.
That.
That's a really good question. Have one of those.
I just wanted to have a good example to look back on for everything that we're and thank you so much for the thought to use Notepad as I'm in the lecture. It's actually really helpful for me.
Oh, good. Okay, great. Yeah. It all comes down to active listening. I don't want you just listening. I want you to be creating something, adding something, value adding something. All right, and the mischief rule case was Hayden's case. That's it. All right, but that's a good, I like your question, Lachlan. So everyone should come up with their own case for the golden rule and have an example ready to go. Really handy, and don't just consider this information as something that you use while you're studying statutory interpretation. There's no reason why you can't refer to these things appropriately when you're studying contract or tort or criminal law. You know, these statutory interpretation is meant to cover all cases, all situations where you're dealing with a statute, which is pretty much every time you deal with a legal matter. So this is what I call level 4 preparation. Have you all seen the video level 3 preparation for exams and short window take-home papers? Do that. I'll show you where it is shortly. But when you look at it, you'll see what I mean by level 3. Level 4 is taking level 3 and using it everywhere, not just for the purpose of the examination or the take-home paper. Okay, so the purposive approach is what we do now. At common law, the approach was only used, so we did kind of have a purposive approach, but only in circumstances where there was ambiguity. Now the modern approach is to consider the purpose, consider the context at first instance, and not merely at a later stage. A case that's very important in that regard is, and this is another go-to case, CIC Insurance against Bankstown Football Club, 1997, 187 384. You'll notice there for both those cases I've given you the authorised citation, which is the Commonwealth law reports. You'll find that many of these cases are reported on different platforms, but generally there is only the one authorised platform. The significance of that is that even though the words might be the same, in different forms of reporting, when it comes to presenting a case in court, the judges require you to provide the authorised citation and only use the unauthorised citation in circumstances where there is no authorised citation available to you. Keep that in mind. All right, let's have a look at Moodle. I just want to run through a few things. This is a bit of a refresher, and if you have any questions, please feel free to ask and do that now. Now, I take it that most of you are in first year. I might be wrong, and I should know that. I have access to that information. But let's assume that you're still new to Moodle and this whole process. You need to have a thorough look at not just the information that you need at the time on Moodle, but what do we need to do? We need to adopt a full context approach to Moodle. We need to look at the whole thing. We need to work our way back, and we need to look at the various parts to get a feel for Moodle. It's the same principle, and you'll find you apply this idea throughout law completely. So top left-hand side, we have the assessments. The first one is out now. The second one is not yet released, but I will release that in the next week or two. And down the page, we have Q&A. I mentioned that earlier. Let's just go in and see if people are using it as a random thing. So we have, excellent. So Amber, Jana, is it Anthony? Anthony? Sorry, Ahonda, Gary and William, congratulations and well done. And we've got a few replies, which is very good. So please continue to use that Q&A section. Likewise, if we move further down the page, you'll see the area in relation to information. This is where I will upload the previous week's lecture. So after tonight, that will change to week 2. Or other information that might.
Sorry to interrupt, John. I'm not sure if it's just me, but on my screen, the screen you're sharing isn't moving at all.
Oh, is not? Okay. Is it now?
No.
Is it? It's not moving. Still not moving.
Yeah, no mouse, no nothing.
Oh, okay. Is it just stuck at the top?
Yeah, it's just stuck at the top. Yeah.
Okay. I don't know, it might be bandwidth problems, so I'll ignore that. But what I'll do is I'll ask you now, if you're looking at Moodle, to follow what I'm saying, and if you're looking at this as a recorded session, please do the same. Thank you for letting me know that, Lachlan. So if we move down the page, under Q&A, you'll see the information, which is where I'll put the latest lecture or tutorial, whatever you wish to call it, and other information that might be relevant. Make sure that you read the next ribbon to do with plagiarism, academic misconduct, and under assessment banner, of course, that's another place for you to consider the assessment material. That's where you'll see the video level 3 examination or short window online paper preparation. Look at that. You'll see access to the assessments, which is a duplication of the access on the top left-hand corner. Below that, you'll see information about assessment and referencing. Please take particular note of that. Have a look at the quick guide, because you do need to know all about the Australian Guide to Legal Citations, and you need to consider the quick guide as an easy way to remember how to reference your material.
Excuse me, John.
Yes.
There is some online tutorials through the ALC now as well for the legal citation stuff.
Oh, excellent. I wasn't aware of that. Thank you very much.
Put them on recently.
Would you be kind enough to do us all a favour, me included, and provide us with a link to that material?
I can't this evening.
Oh, no, you don't have to do it now, but perhaps maybe, if you don't mind, sometime during the week.
Yeah.
And I guess the best place to put it would be in Q&A or general discussion. Because I've lost UCRO, I'm still finding my way as to where to direct people to go for these things. But if you could, Tanya, thank you for that tip.
Sure.
And if you would, that would be excellent.
There's about 3 or 4 videos on it, I think.
Ah, great. Well, that's perfect. Thank you. Now, Michaela says, do you cover week 1 material in week 2, vice versa? The short answer is that I jump around a lot. Sorry. So the approach that I adopt is not linear, and that's quite intentional. But I do generally stick fairly closely to week 1 material in week 2, in week 1, etc. Now, looking further down the page under additional, this past examination assessment, what I'll do is I will upload some past assessments to give you an idea, because I want you to have a look at last year's take-home paper, which will give you an idea of what it is that I want you to do this year, and I'll upload some previous probably take-home papers as well. Now, under additional resources, we have mostly reference material in terms of research, ethical rules, and practice. A couple of things there. In terms of research, have a look at the research videos. There's a folder there. Make sure that you're aware of Queensland Supreme Court Library website. It's really valuable. Definitely look at Queensland Judgments, which is authorised Queensland reports, and consider the flowchart statutory interpretation methodology. You'll find that in the back of your textbook. So the flowchart is a replication of that, which is in the inside sleeve, and it's actually reproduced also in the textbook itself. Make sure that whenever you answer a question in statutory interpretation, or indeed any legal question, that you consider the ethical practice rules. It never hurts to identify an ethical issue, whether you're talking about a matter in constitutional law, administrative law, alternative dispute resolution, or environmental law, just to name some examples. Add something in about ethical rules, and the lecturer, the marker, will be impressed. You do need to know these ethical rules throughout your entire unit, so get to know them quickly, just even in a general sense. Now, remember that there's both the barrister's rules, or barrister's rule, and the Australian Solicitor's Conduct Rules, which are different for the 2 branches of the profession, the legal profession in Queensland. In other states, we have merged professions. Okay, any questions so far? I hope I'm not going too fast, but we've got a lot to cover. All good? All right. So then move down the Moodle page, have a look at the week 1 ribbon, and you'll see the previous lecture is there. Some other material you will find, and there are weekly problems. Now let's have a look at problem 1.2, the role of courts in statutory interpretation, and excellent work by Lachlan Wilson and Aronda Jed.
What did I do?
Hi, is that you there?
Yeah,
I'm sorry.
what did I do?
Yeah, no, good work. You
When?
you answered something in problem 1.2. There were only 2 students who did that. So it's I'm giving you a commendation. So good work.
Did I answer it appropriately though? Did it make sense?
I think you said I concur. So that's good.
Oh,
That's
yeah, no, that was just me saying that there was no question there. It was a statement.
Oh, it's a statement. Yeah, no, that's true.
Yeah,
So
I wanted to know, like, I agreed with what was written,
yeah.
but we all wanted to really know if there was more of a question directed at the statement that was there. Like, what would you like us to discuss in relevance to that?
Right, and Aronda says, yeah, there is no question.
Yeah.
I'm glad you brought that to my attention. I will review that, and that was a terrible example from my perspective. I should have done my homework before clicking on problem 1.2, but I will make a note and I'll add something in there to make it more understandable. Okay, so the key for that is get to know Moodle, get to know how to work around it, and make sure that you're aware of it. Make sure, of course, that you are working on your assignment. And a good way to do this is please don't leave it to the last minute. There's a few good reasons for that. Sometimes people leave it to the last minute and then they tend to copy and paste. Then you've got all sorts of problems with plagiarism, and because you're under pressure for time, that's no excuse for plagiarism. So, but if you do refer to something, please make sure that you simply refer to the original source. The other thing is that if you leave it to the last minute, it's kind of daunting. You've got a blank page. What I'd encourage you to do is have a working document for the first assessment that is readily accessible, and anytime you read something in the text or material and you have an idea, you can add it into your skeleton. So for example, the second matter relates to Project Blue Sky. Come across something relating to that case. Maybe you could cut, paste, have an idea of where it's from, so you can refer to it in your material, and soon you're building a lot of material from which you can draw your response. And odds are that you'll have much more material available to you than the number of words that we've allocated to answer the question. Does that make sense? So treat answering the questions as a progressive thing, and that's really part of what I say in terms of preparing for the take-home examination as well. So you should be aware of the questions. You should have your skeleton, if you like, your template for answering the question sorted out now, and you should be progressively adding material into that so that you are not so daunted when it comes to having to write the answer. I do hope that makes sense. Make sure, while we're on the topic of submission assessment, that you submit on time. Note that I have cut-off dates. Not every lecturer will do that, but I do, and I enforce it strictly. If you haven't yet looked at my sample document, please do so. That, what I call the sample document, I think I've worded it slightly differently, and from memory it's under the assessment regime, and it's called Written Assessment Guide Sample Document, and that will give you an idea of the way in which you might consider presenting work. You'll come up with much better templates and look than that. The one I've got is pretty basic, but it gives you an idea. It means that if you're using the Word program, and I think almost everyone does, but if you're using the Word program, in presenting your material, make sure you understand the styles that are built into the Word program. You can modify them to suit your taste. You absolutely must know how to use footnote referencing. If you don't, please ask. Someone will help you. It's really easy, but you must know how to use it now. Make sure that your presentation is professional, and make sure that you don't fall into the trap, which I see often, of people cutting and simply pasting, which means that it's so obvious that something with a different font has been drawn from elsewhere, and you get pinged up. You turn it in, will catch you, but it just looks like you're plagiarizing material if you just cut and paste and it's a different font. So you need to have some degree of professionalism in terms of proofreading. All right, so enough of that. Now, turn it into super vigilant. It is. But don't stress over it. Don't stress over it. Now, material facts. We know that legal reasoning, legal logic suggests that one way to approach a problem is the IRAC method, where you consider the issues, you consider the rules, you apply the rules, and you come to a conclusion. But I think before you adopt IRAC, you need to consider the material facts. So it almost becomes MIRAC or MIRAC, M-I-R-A-C. And I hope you know what I'm talking about. If you're doing Introduction to Law or have done, you'll have a fair idea of what I'm discussing. But the material facts are important because anything that is critical to the decision is probably a material fact. And if it's a material fact, then you need to consider that within the context of the statutory provisions, which is the statutory interpretation component. So you can't really answer a question on statutory interpretation unless you've first identified what is a material fact if it's a problem-based question. In other words, there's not much point answering something about interpretation if it really doesn't matter, if it really wouldn't affect the decision. I hope that makes sense. So bear that in mind in all of your answers to legal problems and certainly in relation to statutory interpretation. Okay, where do we find our law? Can anyone tell me one website that works well for them in terms of finding law in Australia? And we're getting the votes coming through now. Jade, Queensland legislation, anything on the government websites? Yes. A few for Austlii. Federal. So these are all good answers. Westlaw. You're right, at this stage, make sure that you look at all of these and find what you think is the favourite. I tend to use Austlii a lot. It's not authorised, but it's still very authoritative, and actually some parts of Austlii are authorised. So let's have a look at Austlii. I know that this is something that you'll be doing in Introduction to Law, but given that you're starting out in your studies, you really need to know your way around, and I do encourage you to explore. I'm going to try to share the screen, and I do hope that it works reasonably well on this occasion. So simply for Austlii, and you should see the Austlii landing page there now. So Austlii, go to, for example, Commonwealth, and I do hope that that's showing up and changing. Then you can go to Commonwealth legislation, which is the third box along, and you can go to Commonwealth Acts. And is that changing, Lachlan? Is that changing from one screen to another, or is it still?
Nope, not at all.
No,
not on mine anyway.
Still showing just Austlii.
It says right. Australasian Legal Information Institute. And oh, hang on.
No, has it changed now?
The mouse just moved for a sec. Try moving your mouse again.
Yep.
No, it's not moving.
No, not moving. All right. Well, I'll abandon that. Sorry. I'm not sure what's happening. Usually it works pretty well. But I think where I am, our broadband is about a month away. So that should improve things considerably. So what I'm going to ask you to do is this. If you've got Austlii up on the screen now, have a look at have a look at Commonwealth legislation. And let's see who can do this the fastest. Can someone tell me what section 15A, no, we'll make it, can anyone tell me what section 3, capital A, subsection 2 of the Commonwealth Acts Interpretation Act says? If you're watching this as a recorded session, please push the go button now.
Commencement of acts?
Yes. Section 3A, capital A, subsection 2. And we had an answer. Who got in with that answer? I just couldn't say. Gareth, well done. Good work. Jana's printed the whole lot. Excellent. Am I pronouncing your name correctly there, Jana? An act?
Yeah, you are.
Okay, thank you. Thank you, Jana. An act other than an act to alter the Constitution commences the 28th day after the day on which the act receives the royal assent. Okay, so have we all found our way to section 3A, subsection 2 of the Acts Interpretation Act, Commonwealth? Now, when you read that section, do you understand what the words mean? Do we know what we mean by an act? Do we know what we mean by the Constitution? Commencement, well, that's pretty obvious. Do we know what royal assent means? Do we know where to find where this royal assent occurs? Who completes the royal assent? Do we understand the difference between the Parliament, the executive, the courts? So there's a few issues that arise from reading that, and I'm not asking questions now, and I'm not answering. I'm not providing answers, but I'm just asking you to develop this practice of reading critically, so that you're not just answering something, but you're understanding it more as well. And Timothy says, is it connected to a bill? Yes. So this is a really good question. So when legislation becomes enacted, it goes through a process. It will be a bill at a time. And this section is all about that process of the transition, if you like, from a bill to becoming an act of Parliament. Excellent. Now let's, can anyone tell me what section 15A, section 15, capital A of the Queensland Acts Interpretation Act says? And not via your textbook, via the online resource of your choice. Sky, well done. We'll see who comes second, Sky. Jana. Oh, sorry. Section 15, capital A. Gareth has come in second. So well done, Sky. Well done, Gareth. Who else is finding it? Section 15, capital A, Acts Interpretation Act, Queensland. I'll put the pressure on. I'll do a countdown now. Megan's in. Oh, we're coming in now. 5, 4, 3, 2, 1. Okay, well done. So plenty of you found it. These are, of course, critically important pieces of legislation. And those sections are similar in terms of the intent, but different in terms of the detail. So you'll understand that there is this distinction between the way in which Commonwealth law comes into existence as opposed to state law. And looking at those two sections, you'll see some difference there. One is 28 days after royal assent. The other is upon royal assent. So make sure that you have ready access to these things. Put them as part of your toolkit, for want of a better term, because almost invariably you will need to refer to these sections when you're dealing with the interpretation of a Queensland Act or a Commonwealth Act, respectively. You'll need to know...
Just a bit of a side question.
Yes, Gary.
A red herring. Is there any reason why the Commonwealth has enacted 28 days after it receives assent?
No, I think really, I honestly think really personal preference.
Gotcha.
And I think it really comes down to that. And you'll see that a lot during your studies, that the state-based legislation is potentially similar, but not the same. and sometimes we have different states adopt different practices. So if you're in a jurisdiction other than Queensland, please look at your Interpretation Act and look at the relevant section in that regard. What you'll notice is that we often use plain English drafting, and that's an important thing for you to be aware of. But sometimes the plain English drafting can create some problems. And where we have a situation where we're trying to simplify legislation, sometimes the question might be asked, by simplifying the language, changing the language, has Parliament shown some attempt to alter the law in a different way? Just keep that in mind. So when you're looking at legislation, be aware of that general rule for it to change. A case that you might want to consider, Commonwealth Commissioner of Taxation against Stone. The Commissioner of Taxation against Stone. It's in the textbook. It's 2005 222 CLR 289. And I think it's at page 20 of your text. So do have a look at that case. Yep, at the top of page 20. In that case, it was accepted by the taxpayers. The taxpayer's principal motivation was the pursuit of excellence and the pursuit of honour and of self and country. But taken as a whole, an athletic activity during a particular income year was still constituted to conduct a business. And the conclusion proceeded from the acceptance of a proposition that she'd turn her athletic talent to make money, and it was more than trivial. So that case talks about, if you like, purpose. And someone mentioned earlier the value of going to government websites, and I'd really encourage you to do this. Some excellent material on statutory interpretation by the Australian Taxation Office called Interpretation Now. If you can find your way to that, that will have some wonderful material that will assist you in terms of dealing with statutory interpretation problems. I mention that because there's reference on the ATO to their view on this case. And that's a slightly different area than the Interpretation Now. But you can look at, say, law.ato.gov.au/ATO law/view. So try and find that. Just go around to the ATO website and you'll find that there's a lot of good material that will assist you. Okay, I know I'm moving fast and I'm giving you some homework, but that's the way it works. In Queensland, we have explanatory notes or explanatory memorandum or memoranda is the singular. Queensland, explanatory note, write the word note, or memorandum or memoranda. What do we have in Queensland? We're getting some votes coming in now. Note, note, note. And those that haven't answered will hear me and say note. Correct, note it is. Commonwealth, called it explanatory memoranda or memoranda, same thing. Parliament will often create legislation using different groupings, and you'll get to know the different terminology for those groupings. So there might be chapters or parts or divisions or subdivisions. So get to know that and start to use that. It's a good way to guide your way around legislation. Speaking of guiding your way around legislation, if you can use bookmarks or headings and shortcuts, maybe search engines, those sorts of things are all very good. Question, do they put the notes at the end of the first reading? No, the notes will go in, explanatory notes will go in typically a little later, I think, in the second reading. Actually, I'm not sure about that. I should know that, but I think they do come in a bit later. And you can access the notes through Austlii or Parliament, generally speaking, on the website. So in your toolkit, make sure that you've written down where it is that you will find the explanatory note if you're talking about Queensland, and where you'll find the explanatory memoranda if you're talking Commonwealth. there's more than one place. Try and find at least one that works for you. What happens to the notes or amendments made to a bill before introduction to the third reading? Well, the answer is that those remain on the website and are available to you for future reference. Particularly important when you're dealing with statutory interpretation, because if we're talking about purpose, context, intention, then we want to know what led to Parliament introducing this law. To use the old common law phrase, what was the mischief that Parliament intended to deal with in enacting the law? The best way is to look at the second reading speech, or from my perspective, even more, look at the explanatory memorandum, the explanatory note. It will give you a lot more information as to what led to the bringing in of the legislation. If you're answering a statutory interpretation question, please always refer to second reading speeches and or explanatory notes or memorandum. Sometimes I specifically intend to see that on your paper, but if not, it's always a good idea. Often in court, I will, when I can, refer to the explanatory note or explanatory memorandum. It's hard to argue that that's the intention of Parliament if you're actually using the words of Parliament that were created before the introduction of the Act. So what happens if you can't find the notes for that amendment before the enactment? Yeah, sometimes you won't. Sometimes you just won't be able to find things. And in other words, these things do not apply to every act or every amendment, but you might find different sources of, different platforms have different access to some information. So for example, in Austlii, from memory, you can find the explanatory notes in Queensland, but only from 1999 onwards. Before that, you have to source it elsewhere. So your task is to find these different avenues for accessing the information, record it in a logical manner for you in your toolkit so that you can, under pressure, find these things if you're dealing with it, say, in a take-home paper or exam, or you're preparing for a court matter. Please remember all of these things beyond statutory interpretation. I want you to remember these things when you're dealing with the other subjects that you're studying during this law degree. You will get better marks if you refer to these source documents to support arguments. Does that all make sense? All right, now question there. Victoria, John says, Victoria has explanatory memoranda. Thank you. Tim says, is there such a thing as a fourth reading if Parliament cannot get the bill correct? Yes, there's no reason why it can't. Janice says, I believe they come back to it after 3 months. Wasn't sure about that, but no, thank you for that, Jana. Okay, so before next week, you must know how to find all of these resources. And if you have any problems, please ask. Have a look at the research videos that are on the website, some of which I prepared, and do look at different resources. Now, I'm going to ask you to find something that will be a terrific resource for this subject, this unit, and beyond. It is, in Queensland, the Legislation Handbook. Has anyone accessed the Legislation Handbook already? It's a good resource. Okay, looks like maybe not yet. So have a look at that, and let's end this evening with some homework. I want you to find section 6.11 of the Legislation Handbook, which is developed by the Queensland Department of the Premier and Cabinet. And I want you to tell me what it says and what was the basis for that document to come into existence. Under what authority, if you like, did it come into existence? That's part of your homework. Now, before I wrap up, are there any questions, comments? Are we all good? I will just show you something. I'm going to share the screen. I've been put off sharing the screen. This will be the last thing I do. I mentioned the Australian Taxation Office is a great resource. Another good one when you're dealing with High Court decisions, and in statutory interpretation, you do tend to deal with High Court decisions a lot, is the High Court of Australia website. I'll share the screen. I'll show you the website in relation to the Commissioner of Taxation against Stone case. You'll see the reference there. The citation is the High Court of Australia citation. You know, I mentioned before the authorised citation, which is the CLR. You'll see that as one of 4 citations for this one case. So the main citation here, given it's the High Court of Australia website, is its own resource. So the High Court of Australia website has some information, has the PDF, has assistance that will help you in terms of answering questions for this unit and beyond. All right, so question, please say again the section to look at in the Queensland legislation handbook. Lachlan's right, it's 6.11. Now, question, do we learn about the layout of the citations? Yes, as we go, and a good place to start is the Australian Guide to Legal Citations. Have a look for the quick link, which provides an overall summary, and that will assist you in terms of the layout for citation work. Great. All right, you've been very attentive. Have we learned a few things tonight? I hope so.
You've probably seen a more quiet side of me, so be prepared for that.
Oh, okay. So there'll be more chat later.
You'll see. I think I probably put Amanda in a state of shock yesterday with how much I didn't shut up.
Oh,
probably
okay.
annoyed half of the people in this chat.
Are you giving me forewarning?
More or less, yeah.
Now, sometimes I come online at 7, sometimes at 7:02, sometimes at 6:55, sometimes even a bit earlier. But I'm going to ask a favour. If I come on at 7 o'clock and the chat room is silent, I won't be pleased. So do you understand what I mean? You can come on earlier, and if you want to come on at 6:45 or whatever and just have a chat amongst yourselves, please do so. I encourage it.
I'll jump in and be as thought-provoking as I can be.
All right, that sounds good. That sounds good.
Thank you for the lecture, John. It was a pleasure.
Okay, thank you, Lachlan.
Thank you.
All right, well, thank you all for attending this evening. I really appreciate your attendance and commitment to the unit. Please share information. Any questions before we go?
I'm off to watch the new Harry Potter movie.
Oh, okay. I didn't know we had a new one. But that sounds good. All right. We'll see you next week. All the best. Bye then.
Thanks, Ed. See you, everyone. Have a great night.